does mediation work in New York divorces?
So there's one of two ways mediation can work in a New York divorce. One is that the parties will just contact a mediator on their own, even in advance of filing a divorce case, and just initiate the process. A lot of different things can be resolved in mediation, such as asset distribution, maintenance, child support, custody visitation, pretty much any other issue that would be resolved in the divorce case itself, except for termination of the marriage. Um, uh, a kind of side way that parties can do mediation is that they can file the divorce case and get a referral to a mediator from one or both of the attorneys on the case. That is usually the recommended approach, such that it, especially from the moneyed spouse's standpoint, it'll cut off accrual of marital assets. It'll also cut off the potential duration and limit the amount of maintenance, because those calculations are based on the date of filing of the divorce case. So in that instance, the parties can retain their own attorneys, get the divorce case into court in terms of just the filing, and then kind of park their respective attorneys off to the side and then go to mediation. So that's one route. The other route is the parties can, again, both retain their own attorneys, get into the divorce case itself, and maybe in the context of a contested case, they get before the judge. There's no orders of protection, and they say, "Yeah, we're both amenable to mediation." In which case, the judge can basically say, "Okay, I'm going to give you a longer compliance conference date." In that instance, with the hope that you're going to be able to resolve everything in mediation, and then the court will make a referral to their own mediation program. That's generally the protocol in the greater New York City area. I would expect there's some somewhat similar mediation programs in upstate courts, though I'm most familiar with the downstate courts.
So what unique role does a mediator take in an uncontested divorce?
So in an uncontested divorce, again, the mediator can resolve every single issue other than termination of the marriage that the attorneys would resolve. So if you're successful in mediation, then that's going to produce a settlement agreement, also known as a stipulation of settlement. It's the exact same document that the attorneys would produce. So there's literally no difference between whether a mediator does a settlement agreement or whether the attorneys for the respective parties does the settlement agreement. Where it is successful, then the parties end up saving money, because they're just retaining one attorney as opposed to paying two attorneys to negotiate and draft the settlement agreement. Where it's unsuccessful, then the parties may end up paying even more than they would have if they just cut out the whole mediation process in and of itself. So it's a bit of a gamble, and the gamble is really based on the party's own assessment of the likelihood that they're going to be able to reach an amicable resolution in mediation.
Right. So, and that was, so my next question would be, do both spouses always need to agree to mediation before it can happen?
The answer is a short yes. Mediation in New York cannot be forced, even by the judge. So even in a contested case, you get before the judge can highly recommend mediation in most cases, except where there's domestic violence. But the judge cannot force the parties to go to mediation. And indeed, the judge cannot draw any inferences against a particular party if they just say, you know what, I'd rather not go to mediation. That's their right and their option, and that can't be counted against them.
Hmm. Right. Well, how can somebody prepare for divorce mediation sessions?
So you would prepare in a similar fashion to how you would meet with your own attorney to go over settlement terms in an uncontested divorce case. So, what I mean by that is oftentimes the mediators will give you a questionnaire to fill out that's kind of going to outline uh, what you have in terms of assets and property and uh, debts, things of that nature, expenses. They may have you do a formal net worth statement, though a lot of times the mediators don't have the parties do that. It's not required. It's usually recommended, but some of the mediators just give the respective parties questionnaires. So obviously, as part of the preparation, you'll want to carefully fill that out. And if you've done the recommended approach, which is to have your own attorney, you'll want to go over that with your own attorney. There is a role for attorneys to play, which is to advise their clients on the preparation process. As part of that preparation, you'll want to know what it is, that you really ideally want, but also what your bottom line that you're willing to settle for is. And so you'll kind of go in to the negotiation process asking for something close to the best that you may hope to get, and then kind of whittle it down from there and hope to reach a middle ground. But it's pretty bad negotiating skills to go into mediation and say, well, here's my bottom line, and I'm not moving one iota off all of these issues. Well, then it's going to be a real short mediation process if your spouse doesn't agree to every single one of your demands, so to speak.
Which does lead me to if mediation does fail, what happens? I know it's an uncontested divorce, but does it become contested all of a sudden?
Not necessarily. So if mediation fails, then the parties just go back to their respective attorneys at that point. And they say, well, hey, look, we tried mediation, didn't work. Now we need the attorneys to step into the mix and try to negotiate a settlement agreement. Here's where we left off. Here's where the impasses are. And then see if the attorneys can negotiate amongst each other and or at a four-way settlement conference. That all can definitely be done. And I've been successful in reaching settlements where the mediator was not able to. Here's the limitations of mediators. The mediators are not there to tell parties, this is what I think. This is what I recommend. This is what I think the judge will do in your case. The mediator can't say any of that stuff, unlike your own attorney, where they probably should in a lot of cases, especially if the recommendations are pretty clear in terms of what the impasses are. So I would definitely say that settlements can still be reached, but you have a short time frame. The courts are encouraging attorneys, even via court rule, to file for a contested case within 4 months. So if you've already spent a month or two or three in mediation, you're really only giving your attorneys about a month or two to negotiate a settlement before they're really supposed to contest the case.
Um, so in your opinion, what qualities make a mediator effective in facilitating a smooth, uncontested divorce?
Um, being sensitive to both sides, being receptive to both sides, having a big menu of options in terms of how things can go one way or the other, and to take the time to review all those menus of options. The good, successful mediators uh, will be able to break impasses, as but one of 100 different examples. Father comes in and says, I want shared custody, and I won't settle for anything short of shared physical custody. And mom says, geez, I'm not willing to give shared physical custody. Well, that would otherwise be, an impasse that, a poor mediator would say, well, gee, there's nothing I can do. So I got to refer you back to your attorneys and have a good life. Um, but good mediators will say, wait a second, well, what are the real issues? What are the real concerns, from dad's end or mom's end in terms of mom not wanting to agree to shared custody or dad insisting on settling for nothing but shared custody? And kind of trying to flush out what the rationales are and seeing if there's still a middle ground that can be reached. I know I've done cases where mom says, well, look, I'm the one that really does the homework with the kids. Um, and dad is really kind of hands off on that issue. And my concern is that if we split time, the homework's not going to get done. And or, um, let's say mom lives in a better school district than dad. Then it kind of makes sense to have mom be the primary custodian during the school year. But that doesn't mean you still can't do shared custody, because shared custody would look at the entire 365-day calendar and count up the number of days, divide by two. And if you can do something that's roughly 50-50 time, you got shared custody. So under that circumstance, you would be trying to work out a settlement whereby dad gets more time on breaks and summer vacation, and mom has the vast majority of weekdays during the school year, and maybe dad has the vast majority of weekends. Maybe 3 out of 4 or 5 weekends, or something along those lines, so that when, like I said, when you look at the entire calendar, they end up at roughly 50-50 time. Good mediators are going to have the patience to work out that kind of schedule.
Hmm.